Okay, so we finished the part of the conference in terms of the panels we had, but if you don't mind, we will move without a break to our I would say that the most important part of this workshop. Eleanor Fox kindly agreed to deliver a keynote at the end. Thank you, Eleanor, for being with us. I don't think that for us, Eleanor requires any introduction. So let me just say that we would like to learn from your experience as a citizen of the world. You did a research in competition law field concerning different countries, different continents, and you were very often thinking how to make competition law inclusive. So we would like to hear from you. Thank you very much for being with us.
So thank you very much, Maciek. It really is my great pleasure to be with all of you, and good wishes to all of you. I see many friends. I do have slides, and I will share them now. Just a minute. Okay. So Maciek, you asked me to talk about transitions and assimilating the highest values in the competition law of the transitional countries. As I developed my thoughts on the subject matter, I'm not talking only about a period of transition. I'm really talking about what these countries that are transitional countries need and want, and out of their competition law, and how do they get that composite of values that they do need and want from the competition law. So my thesis is that something very interesting happened in the field of competition law. It was actually mostly pioneered by the United States. And although the United States had this period of time of great flowering of principles that were not just efficiency principles, from the time of 1980 on to the present day, United States has incorporated, first little by little, neoliberal premises and got to a very narrow view of efficiency, and was basically selling this as the way to do competition law. And then, of course, the EU came on stream in the late 1950s, early 1960s, with a different foundation and basis. But still, this concern and even formulations of US law have been incorporated to some extent into the EU law, so that what had become the model of international standards was rather narrow. And when the transitional countries, here I include Global South, I include the CEEs, when they sort of came on stream and into their own rights in thinking what is their bottom, their foundation, they began to formulate the principles, the objectives differently, the principles differently, and even what efficiency means differently. So here where I say on the slide, the transitional countries' values are worn on their sleeve, and they're giving an occasion for thinking about a composite of the market and human values, deliberatively at the foundation of the law. As Dennis Davis said half an hour ago, there has to be some infusion of the economic side and the values side And it's that kind of infusion that really is at the basis of my thesis, because my thesis is that by a kind of stealth, neoliberalism was built into US law and had some export around the world, often not intentionally, not even knowingly. And that foundation has to be replaced, and indeed can be replaced by this fusion, this composite market and humanism, without any loss of efficiency. Once Global South and CEEs retake the word efficiency, redefine what it means to them, and given the fact that I will refer to US law a lot because it makes things so clear in terms of contrast. The US law has gone so far in privileging even dominant firms on a laissez-faire principle that although they say in the United States that the US law is for efficiency and consumer welfare, it actually does not go always in the direction of efficiency. It goes in the direction of privileging the dominant firms and privileging the status quo. That's why there is so much space to say, we have a view of our formational values, and it is efficient. And we can do both at the same time. But to do this, one has to recognize where you also cannot do both at the same time. And I'm not leaving that out. That's very important. Like, you cannot say we want a society with actual outcomes of equal wealth all the time and get it through competition law. And I'm not arguing at all to stretch competition law in that direction. So I will say a few words of what I think the CEEs have contributed, even though, of course, your countries in Central and Eastern Europe have huge challenges. I'm not ignoring that. But I want to take what I think is some of the best in terms of contributions they've already made, that the West and the global North ought to be considering, and the same with the global South. And then we'll get specifically to some of the highest principles and how this can be and should be adopted in the law, and indeed is being adopted in the law. For example, South African law does it very well, with some problems on the side of perhaps extending too far as to make an inroad into what the market can do well, as Dennis said, and I will come to that. And then in the very end, just to conclude, because my main thesis is where are the complementarities and how to nurture the complementarities. So here, I know I'm going to say a lot of things I hope you won't think are trite because you know them, you're all experts, but I'm saying things that you know very well because I think this sort of emphasis and formulation helps me come to my thesis better than leaving out everything you know. Okay, so why countries adopt antitrust laws, there is a range, and I will say a few more words in a little bit about why did the CEEs, why did South Africa and African countries. And I want, of course, many countries adopt competition law in order to help make their markets work better, to produce better goods and services. And also, when you ask, what can antitrust do and even do well to meet needs of people in transitions, totally consistent with that idea of making markets work better, is the openness value and the access value, which you can also articulate as a human rights value, contestability value, opportunity, equal opportunity value, independence of the agencies and due process and a fair chance. And that is a cluster that I'm saying is a cluster that is at this fusion of humanity and efficiency, or you can say markets and human values. In the United States, as I mentioned, there is a real, what I call fallacy in the law, although there are many people in the United States and elsewhere who do not think this is a fallacy. And this I call the Reagan-Scalia fallacy, which is neoliberalism. In the United States, when we had our big turn, when the Reagan administration came in 1980, our law was kind of having no bounds and limits and was like prohibiting almost every merger and was on the side of the underdog in every case, great, but had no boundaries and was interfering with the efficient operation of business. So it wasn't surprising at that time that there would be some limit put on our law. The problem was that the school of thought that put the limits on our law sold their economics as the economics of antitrust, of course, Chicago School. And the question was phrased as if, should we be adopting economics as the basis of the law? And if the answer was yes, it was like Chicago was slipped right in. And of course, that was and has been a huge problem because there are many ways and different ways of analyzing what would be an efficient environment and efficient outcomes. So it's very interesting that in the United States, again, in the last even 10 years or 8 years, there's been like a public, very small letter R, revolt against this view of the market, what it can and does deliver, what it doesn't deliver, and what antitrust should do. And even in the last month, there have been several major articles in the press saying the neoliberal consensus is dead. People do not believe in it. The neoliberal consensus is, of course, the same as the Washington consensus. What we have US from the Supreme Court in our antitrust law is still the Washington consensus. The problem is, to most of the people, neoliberal consensus is dead. It's wrong. It doesn't deliver. It ignores realities of power and distribution. But our Supreme Court is neoliberal on balance. So I'm going to be asking along the way, what can antitrust deliver more than the traditional, which doesn't have to be neoliberal, idea and values? And I argue, as I already said, that confronting the myths of antitrust orthodoxy reveals a large space in which markets can do what markets do well and do equity at the same time. So this slide is, as I call it, a cautionary backdrop. It's really to think about my thesis against the antitrust orthodoxy, which is probably most orthodox in the United States, and which is very influential in what is called international standards loosely. There's not quite such a thing, but it is embedded in what is called international standards. And so from the US point of view, when this point of view came in, beginning 1980, but very, very much adhered to today in US law as formulated by the Supreme Court. One, be very, very careful in your rules of law on antitrust not to protect competitors. You want to protect, it's okay to say competitive process with a view to looking at consumers as your big proxy to get efficiency of the market, but do not formulate rules that will protect competitors, or the prices will go up and the pie will shrink and everybody will be worse off. Number two, that efficiency is, and you can define it broadly, it's the North Star. And then they define it narrowly because it's defined by laissez-faire. And I have as a subpart of this the Calder-Hicks principle built into US law and many other laws, If winners win more than losers lose, that is efficient. And then the idea is, if it's efficient, let it go, don't interfere with it. And to top it off, that what business does is efficient, presumptively. So the question is, under that formulation, whether the existing distribution of wealth, given the existing distribution of wealth, and what people will pay, want to pay, the particular conduct or transaction enhances or reduces aggregate consumer surplus. So you can see the interplay of these factors. Distribution is not a value. And don't worry about it, because everything will trickle down. And the antitrust is not relevant to interfere unless the transaction or conduct actually reduces aggregate consumer surplus. And within consumers even, you don't look at who wins and who loses, and you don't look at who are poorer consumers and who are richer consumers. And that if you ask, the theory is, if you ask any other question, you're going to shrink the pie and make everyone worse off, and they will argue it will make even the poorer populations worse off. So this is what in US we're dealing with and trying to change the trajectory. And what I'm going to end up, and I've telescoped to propose, is extremely difficult to change, extremely difficult to introduce, to change the hidden foundational premises and introduce a new foundational composite. So very interesting that the CEEs and developing countries, and South Africa was out in front, called up all of these assumptions short, and they wanted markets to help the people by simply what markets do, providing goods and services, but something more. And they put on the table, in effect, what that something more would be. And even if I could refer to International Competition Network, I should say this though, till I get to Global South, because this is really South Africa put a new way of thinking about the composite on the table. So for the CEEs, this is very interesting, because going from planned economy to market economy, going from the plan to the market, was expected to be democracy of the market and expected to make people better off by markets helping the people, partly because I should not be the one saying this, because most of you know better than I, but the scarcity of goods, the standard of living without markets and with planned economy was not acceptable. So markets were needed for purely market reasons and wanted for purely market reasons. The opportunity to participate in markets was fundamental. The need to control private and public power was fundamental. And all of this fits really closely and tightly with any view of efficiency. In addition, in all of the laws of the Visegrad countries, and I don't recall all of the rest of them, but this is from usually 1990, sometimes 1991, the laws always asked more. And all the Visegrad countries had a provision in the competition law against disproportionate or onerous terms. So this means distribution is important, and distribution is something that must be in the competition law. And distribution was very important because of the fear. Again, most of you know better than I, so I glean this from some of your scholarship, The fear in 1990 that adopting markets would actually transfer power to the private firms instead of the government. And if they weren't careful, it could just be replicating who had which autocratic authority had the power. So the need to put lids on greedy private firms led to this additional clause in all of the Visegrad countries, a law against disproportionate or onerous terms. Now, turning to the global south, and I'm going to talk mostly about South Africa, which has been very influential in putting the case to the West that the paradigm of the West is incomplete, or at least a huge number of countries think it is incomplete and in many ways wrong. So what did the people need from competition law? There was, for the new South Africa, there was a choice made as to what would be the new economic system. They were thinking a lot of nationalization. Mandela himself said he was committed to nationalization, but then was convinced, apparently at a meeting in Davos, that nationalization would be a bad choice because it would mean that South Africa would lose channels of investment that it would otherwise get, and South Africa wanted to build up, I'll call it the efficiency and efficacy of its firms and be a player in the international markets. So South Africa adopted markets and competition law, not nationalization. And given that getting the transformation that the country wanted desperately and needed, they hoped and thought that adopting markets and opening the markets would do it, and it would transform. And if markets actually were neutral, and if the people that had been this huge left out majority had the education and training so that they were well positioned to engage, yes, the markets might very well have done a lot of the transformation. But of course, that did not happen. And there is still now extraordinarily high percentages of all white ownership, leading to the scenario that Dennis Davis mentioned. So when you ask what else did the people want of competition law, of course, racial and social justice, and the 2018-19 amendments bring that to the fore and provide the basis in South Africa, which definitely has a composite humanity, dignity, and efficiency market space. For the rest of the global South, there's a lot that's similar, and I didn't mention, but should have mentioned, the fact of poverty, and of course, Vela mentioned this before, the fact of very severe poverty, and I'm sorry, I have to get something out of my way on my computer. The corruption, fighting colonialism, the need for neutral markets, not privilege or power, and the great need for inclusiveness, which becomes one of the big points of the value at the foundation. There is certainly a point at which people need something more that markets can't deliver. And I'm using positive discrimination, such as Dennis Davis was mostly talking in this area. And I'm not building on that right now. I just wanted to mention it, that there's an area that's certainly outside of this space that I say exists for efficient antitrust that also promotes the principles of dignity and humanity. So you have to ask to what extent these highest values are symbiotic with what markets do well. And I believe that there is a strong compatibility with many of, but not all of, the humanity dignity values, or parts of the humanity dignity values. In addition, in South Africa, you have Mediclinic and the Chief Justice saying that the dignity, humanity values are at the base of South African law generally and must be built into the South African law. So this in itself, wow, makes it like 180 degrees from US law, which has no positive social values in the Constitution. If there is and should be this composite, which is built into the foundation, what would it do? And where would you see it evidenced? There are various places, and I don't have time to go through all of them right now. Let me just mention one, which I think is the most obvious, and it is on defining exclusionary offenses. In the United States, it's very hard to prove an exclusionary offense of even a monopoly firm, as you can see from our cases, Trinco and Linkline, for example. To define the exclusionary defense, you usually have to find something akin to, you already have a monopoly firm. You have to have a monopoly firm to be able to control the conduct. Then you have to have an anti-competitive conduct, and the anti-competitive conduct alleged is exclusionary practices. You have to show that the exclusion or foreclosure or partial foreclosure of the competitor or the harm to the competitor of that sort is translated into market harm, such as output limitation that raises prices to consumers. And almost everything the dominant firm does, they can usually justify everything in terms of, oh, we were trying to do this and we'll get a better product for consumers. The stronger that argument is, oh, we have this very good intention to deliver better, there's just no exclusionary practice allowed. So in South Africa and many of the African countries, I think most, when you look at an exclusionary practice that is not your focus, the exclusionary practice definition, as in the CompuTicket ticket in South Africa, you're looking immediately at barriers to entry of smaller firms to get in, survive, and participate on the idea that if it works out, in fact, because there has to be the factual background, it makes a difference to competition in the market, across the market. That opens up huge space for many practices to be called illegal exclusionary practices. So far, I've just been talking about the substantive law. There's also a huge amount of institutional framework that should also go at that base. And I would defer to you, Maciek, and your wonderful work, Populism and Antitrust, and others of you in this audience who have done wonderful work, Hati, also wonderful work on due process and rule of law and its relationship to democracy and governance of markets, not by power and privilege. And here, let me mention briefly Umut's presentation earlier on backsliding. When you have backsliding in substantive law, and you have a chief executive who is weaponizing the antitrust law to serve his interest in sustaining his political power, you are deeply undercutting due process of law. And you are making the law not even law, because it's no longer rule of law. It's no longer predictable. You can't depend upon it. You can't consider it as the economy of, I'm sorry, I meant to say the democracy of markets. It's no longer the democracy of markets. So I have to end within a minute, and I would say, summing up, antitrust law, competition law always has a core from which all the substantive principles are derived. How did the US get its perspective on, for example, its strong principle of no duty to deal? It got it from its core at the foundation of neoliberalism. And here again, I have to say there are many people who defend this philosophy, of neoliberalism as the right value. So we are arguing values. There are very practical implications and applications of redoing where necessary or reaffirming where it exists, this composite at the foundation of the law from which all substantive principles are derived. By working on the core foundation and in sunlight now, rather than in stealth, which US does, and by planting the composite of humanity, efficiency, value in it, here is an interesting effect. You take some weight off public interest as an override because there's a lot of public interest that's built into the foundation. For example, the law on exclusionary practices of dominant firms. If you build that into the foundation, you build inclusiveness into the foundation, you don't have to say, use a US principle and say, is there a public interest override? Yes. Once you get to the public interest override, you bring in all of the problems that Judge Dennis Davis was talking about on discretion, possibility of corruption coming in, and unequal treatment in equal situations. All right, so number two, this paradigm and proposal has specific implications for principles of law. And we've just been through that. The principle of law that would be the law of what is an exclusionary practice is different. It melds the two motivations. And I've listed a number of others in which you just will have a different view of how you get to market power, what is sufficient market power, when is a firm an essential facility that has duties of fair dealing, what counts as efficiency. And I want to pause on this a moment because it is so important to have a good economics that incorporates the inclusiveness values, as I believe was done in CompuTicket in South Africa. That I do believe that a good economics, a good sound economics of antitrust economics for competition law is developing in South Africa, and think that should be noticed, drawn together, and support it. And of course, distribution is very much involved. And when you look at that term and what it means, and you line it up with efficiency, you find that if you move, like if US moved its law to be much more inclusive on exclusionary practices and did it in the name of both efficiency and distribution, it would be a good law. All right, so last slide. Transitional economies, competition law, what do they have to do? And they're doing it. Excise the fallacies of orthodoxy from the core, embed the highest values of humanity, mold what is efficiency that counts in view of what humanity demands, nurture the compatibilities, and recognize the big space in which these compatibilities exist. Thanks.
Thank you very much, Eleanor. So I think, do we want to open this for questions?
I don't have any questions.
It's. I think if there are questions in the room, it would be great. So we have Eleanor, we have Thomas who wants to ask a question.
Hi, Eleanor. Thank you very much for your speech. I was wondering. I mean, to me, it seems like history always swings back and forth. It's like a pendulum going from one extreme to another. I think most of us in this room would agree with you that we disagree with the Reagan-Scalia fallacy. But how do we make sure that in swinging the pendulum back in the other direction, we don't go too far like we did in the 60s and 70s and risk provoking another Reagan-Scalia backlash? I mean, yeah, I think that's.
Yeah, so I'm sure that was Thomas, although I couldn't see you. That was Thomas, right? Yes, I mean, that's exactly a really, really important question. The way to do that is to be clear about when, say, a principle falls outside of this space that I'm trying to develop. And then to treat it separately, because I'm just talking about foundation right now. I mean, there might be some room for public interest, but in terms of the space from which the antitrust principles derive, I think one should be careful, for example, about arguing that you must come to a certain result because of inequality of wealth. You must consider the extent to which applying a certain value will actually put a lid on effective competition and not let the competition in the market serve. So yes, it does have to be very consciously thought out, or we'll go away of the swing of the pendulum and it goes too far one way and goes too far the other.
Thank you. So I think there is one question. Dorothy, you want to ask a question?
Hello, Dorothy. It's nice to see you.
Hey, Eleanor, it's a pleasure. Can you hear me? It's just a pleasure. I adore how you present things, and God, it makes me nice people like you. Anyway, just one real quick remark, because I was thinking, you know, I was one of those people in the early 90s that came to a number of countries in this part of Europe, including Poland, as an advisor, you know, to the Department of Justice, State Department. And I remember but more the economist partner, were really urging the countries in this part of the world at that time, in the 90s, do not introduce the concept of abusive dominance. Don't touch it. And of course, well, they did, because, you know, we did. Now I'm here, but, you know, because of going, you know, harmonizing our laws here in Europe. And, you know, so on one hand, for the US, I mean, I was doing all criminal work when I was with the Department of Justice. So I was at the Chicago school, and the whole change didn't affect me. In fact, they gave us more criminal work because it made them look better. But on one hand, not touching, you know, attempted monopolization for how long, until recently FTC, right, and DOJ, is one horror. On the other hand, you know, living here and representing, my firm representing companies where dominance is, like in Poland, presumed at 40%. 40%. And give me a break. I mean, and then, you know, if you want to really, it comes out to being regulated. And that for me is really, really difficult, because to me, that's an extreme. If you look at, you know, what in the US has just gone unnoticed, and thank God, you know, I totally agree with you, totally. But I really, I'm really not comfortable here in terms of abusive dominance and regulating the market in effect. Anyway, that's just the comment I wanted to make, other than to thank you. It was worth waiting for you. Anyway, thank you.
Oh, thank you so much, Dorothy. So your remarks are very well taken, and maybe I've gone overboard in thinking.
No, you didn't.
Oh, so
I think like you do.
Oh, so I mean, there are definitely those soft spots, and to presume conclusively at 45%, as South Africa does, can be a problem. On the other hand, it could, with a good court like Judge Davis, it could be accounted for if you're careful on the next step, which is, what did you do that was an abuse? That is, you're more on the principle of violation. You've now, on your first step, does the company have enough power? Easy to get through, but the second step, did it do something wrong, or the law says is a violation? If the judges are more careful at the second step, it can give some comfort.
It can, but it doesn't really exist, Eleanor, really. I mean, the comfort, I mean, it is what it is, but you know, I mean, maybe the prices were too high, who knows? Maybe that it was a little bit, it's just a fear, but I think that, you know, ignoring it, and as the US has done, is the worst of the harms. And so I just like to say that it's just strange to be here after advising and then seeing how dominance is put into play, and always worrying about being regulated by authorities who are, you know, it's an easy case. And if the courts aren't going to really be equipped to really to astutely look at it carefully, it could amount to a bit of regulation. And as I have no soft spot for you know, market power for sure, but I just wanted to notice that. And again, I keep thanking you. Thank you.
Oh, well, thank you. But I think your point is so well taken, and that should be on the list to have in mind sort of the rigor of finding that a firm has done something that is and should be an abuse is very, very important. That's why I said maybe I went overboard, because
no, never. No, you have to know. You didn't. It's just I'm giving you a perspective from here, how it looks from a certain side for you or other people to maybe think about in incorporating into the fabric of the pros and cons, or just what you hit it. You need to really look at if there were an abuse, and you hit it. That's the point. Okay.
Great. Thanks. Great comment.
Thank you.
Okay, so I think we can close this part. Thank you, Eleanor, for your wonderful speech once again.
Thank you for inviting me and for convening such a terrific group of scholars. Wonderful.
Great. Thank you, Eleanor. So we will be closing. I want to ask Amber. Amber, are you with us?
Yes, I've been with here the whole day.
I wanted to give really the last time, like really 2 minutes to Joanna to summarize. But so I would like to close on our side. Do you want to add anything? Say anything at the end?
Nothing except a very, very heartfelt and huge thank you to all our speakers. Thank you very much for being here. And of course, to you, Maciej, Joanna, and to Marta for the excellent work on the ground, and to Liat for supporting us in the process. It's been truly inspirational to hear from everybody. Eleanor, I always feel extremely inspired hearing from you. And Dennis, I don't think he's here anymore, but very inspirational. And I hope that we will be able to carry this forward. I mean, that's very much our hope and ambition, really. So I think Maciej and I will be talking about this going forward, and able to come back to all of you with some thoughts of what we may do next. But back to you, Maciej, for an excellent event and for the closing. So thank you.
Thank you very much. So I fully join you, Amber, but I think we'll be contacting you. What are the possible next steps, and we'll just really close very briefly with Joanna, who was taking notes.
Yeah, I was trying to. So yeah, because I thought that I will go back to what you began the whole conference with. So these 3 points, what we're supposed to achieve today, and before we go to the dinner, just to have this feeling that we managed to fulfill all the goals that we had in the morning. So in terms of the question of whether we covered different transitions, I think within the first 1 or 2 panels, we actually discovered that the title of the conference was wrong, because we were talking the title about economic transitions, and then within very short period of time, we managed to talk about political transitions and economic transitions, and the legal transitions as, I think, part of both political and economic transitions, and playing the role in both of these types of transitions. Also, I think we distinguish the transitions from one type of system to another and the evolution within the system, the given system. So I think this is very interesting and something. The thing that worried me after Juan's presentation is that if we have so many problems with economic and political transitions, and if we were to believe many people who claim that we are experiencing the transition of the geological epoch in which we live in to Anthropocene, then we are absolutely not ready for all the consequences of the environmental impacts that this has from the perspective of how the law reacts to them, and like whether we're able to react within the competition law. And as Juan's presentation illustrated, I think not really. And what was important for me in his presentation was this question, which also appeared in other presentations, of the institutions and the skills of people in these institutions. And I think this is important, and I will go back to this in terms of like the motives to which we can, I think, come back in future research. Okay, so on a more positive note, again, the second sector of the question was the different, whether we cover different regions and the transitions in different regions, and I think we all can agree that we managed to do it splendidly. Like we had South Asia, South Africa, and other African countries. We had Central and Eastern Europe. We had South America. So I think in regard to this aspect, we've done really well. And what was interesting for me in this regard were these moments in which we catch some common challenges. And I think, I'm not sure whether you knew in the morning that this conditionality issue would be something actually cutting through the geographical divisions. And it was a nice moment in which I think these various regions actually connected with this challenge and maybe looking for solutions to this challenge above these regional boundaries. And then also the question of the substantive rules that we have in some regions versus the resilient enforcement of these rules, right? So this discrepancy between having really nice openness for various goals in law and then like not having enough resilience within the enforcement. And with this, I would like to come to the third area that Maciej mentioned in the morning, so covering different areas of law. And in terms of covering different areas of law, I think we managed to rather stay within the competition law, with some narrow exemptions of mentioning constitutional law. But within competition law, I think we had many nice issues to follow up in the future. So the empirical research on the effectiveness of the enforcement, like Jasminka's presentation, I think this is really, really awesome direction to go in. Then we had this questions of policies and enforcement. I think that it was present in Thomas' presentation, in Amber's presentation, Dan's presentation, something that was coming back to us from different regions, different jurisdictions. Then something that I was thinking about as I am more, of course, growing from European Union law, actually, I thought about as trap of procedural autonomy. So the lack of belief that actually everything depends on details and lack of regulation of very specific procedural solutions. And for example, the types of solutions that I mean is the role of the third parties or the role of the civil society organization and so on, which was also an issue coming back in several presentations. I think in Kati's and in David's presentation, this was something that was present and I think is quite important. And the last thing that I would like to mention, and also going back to the main idea for the conference, is this question of understanding the goals of law, which Leah mentioned in her presentation, and which I think is also very important for Maciej's project. So we have some, we can be sure that this aspect of the topics we're discussing today will be followed in the project that you just began, right? So this will be all from the summary, and I hope you feel very successful now, having achieved so much today.
Thank you, Joanna, and really thanks to all of you for being here in person or in online. And we can close right now. And many thanks to Marta for being our as well. Thank you very much.